In the Hindu Urban Cooperative Bank Limited versus the State Information Commission case that was decided in 2006, this case laid down the possible test to determine an institution as a public authority. It's quite interesting to note that in the early days, the Punjab and Haryana High Court, in a civil writ petition that came before them, had to decide whether a body satisfies the condition laid down by the legislature in Section 2H. Interestingly, the ambit and scope of the definition of public authority under Section 2H is something that leaves a lot of scope for judicial interpretation and intervention. What it said was very clear, that for any institution to be legally brought within this definition, it had to have the following tests. First, that the institution cannot come into existence and the function unless registered and regulated by the provisions of a legislation. That means that the institution owes its very existence and function to the creation of a legislature. Right? If it does so, then it will be determined as a public authority. Second, that in some sense, either the state or the center has some degree of control on that institution, right, through any act, rule, or any other medium that the government may stipulate from time to time. Third, that it must have some substantial financing provided directly or indirectly by the appropriate government. Interestingly, the court held that the mandate and the command of the provisions of the RTA Act, primarily the preamble, its aims and objectives, extend the ambit and scope of the RTA Act to all such institutions that are having some public dealing or that are dealing with public finances. And hence, you will notice that wherever public institutions are to be brought within the accountability of the RTA Act, they would be brought considering their functions, considering their existence, considering probably the larger public interest that is required in terms of the accountability from these institutions for them to be determined as public authority. And hence you will notice that the test of a public authority is something that Section 2H gives a scope to include as we go by, and you will see in a number of cases how the courts have actually brought in a lot of institutions which were earlier not so within the definition of public authority and within the accountability regime of the Right to Information Act. An observation of Justice Ravindra Bhatt in the Indian Olympic Association case is very pertinent here to note. The judge in this case held that Section 2H recognizes even non-state actors. So it is wide in scope, and it is not a definition that covers only state actors, it also covers non-state actors. And hence non-state actors may be responsible for disclosure of information, which would be useful and necessary for the people that demand the accountability from such non-state organizations. Non-state actors and organizations also serve people. They also serve a public function, and hence if they serve people and public function, it is important for them to ensure transparency and accountability in their functioning, and it is important that such institutions are brought within the definition of Right to Information Act as a public authority, and the process of empowerment of citizens is a continuous process and it must be meaningful, and to make it continuous and meaningful, I think institutions must voluntarily accept themselves to be public authorities. Right, let's go further in trying to understand Section 2H. As I told you, the application, the scope of Section 2H is probably the most interesting one, and the highest amount of judicial activism, if I may say so, or judicial interpretation, or even the intervention of the Information Commission or agencies to be declared as public authorities or not, is something that has brought about a lot of dynamic reading to the Right to Information law. Interestingly, when there is a conflict between an establishment versus funding, which test is more important? So suppose I have to determine whether an institution is a public authority or not. Should I first perceive and see whether it was established by the government, or if it fails the establishment test, can I apply the funding test to bring it within the domain of Section 2H? Interestingly, we do not consider religious institutions as government institutions. In India, there are a lot of religious institutions that are functioning by and under the state. Sometimes the state takes over such religious institutions. Sometimes probably they control the activities of these religious institutions as well. Now, in the case of Delhi Sikh Gurudwara Management Committee versus Mohindra Singh, it was a case that was decided in 2010. The issue before the court was whether this management committee, that is Gurudwara Management Committee, is a public authority under the Right to Information Act. The court held that the Delhi Sikh Gurudwara Act is a law made by the Parliament. So the Parliament has created the Gurudwara, it has established the Gurudwara, and the committee was functioning within the purview of the law. To be precise, the committee was functioning under Section 3 of the DSG Act. The DSGMC is not a body made under any law, but a body made by a law. So there is a distinction when you look at the words that are used in Section 2H, by any law made by the Parliament or by or under the Constitution. So here you will clearly see that if a committee is constituted under an act and the committee is functioning for fulfilling the mandate of the act, such committees that are formed and such committees that enable the functioning of the law are declared as public authorities under Section 2H. And hence, while we say that some of these may not have a statutory establishment, some of these may not have a statutory establishment in terms of creation, registration or incorporation, nevertheless their functioning is within that body that is created by the Parliament, and hence they are accountable under the Right to Information. Let us take a glance of certain cases on determination of public authorities, and these are some fantastic cases in which either the Information Commission or the High Court, as the case may be, have intervened and made certain declarations that are relevant in the context of the fact that you are trying to suggest what are the accountability of this institution vis-a-vis the Right to Information Act. The first among is a very interesting case from the Life Insurance Corporation of India. Now, the Life Insurance Corporation of India has been created by an act, and you will notice that the Life Insurance Corporation is a body that is accountable as a public authority. However, the Life Insurance Corporation of India over time has created other organizations like the Life Insurance Housing Finance Limited or probably the Life Insurance Mutual Fund, right? So LIC has expanded its operations, LIC has expanded its business, and after having expanded it, it has created numerous other bodies. It has contributed to the creation of such bodies. Now, you will notice that when a question arose whether the Housing Finance Limited of LIC is a public authority, in this case of Nisar Ahmed versus LIC Housing Finance Limited, the issue was very clearly in terms of whether LIC is a body established, constituted by the central government. The answer is yes. Further, if LIC is a public authority, right, which has been created by the Parliament, and such an authority creates another body, right? This is like A has created B and B creates C. In those circumstances, the question of whether C is a public authority or not would depend upon what is the control, what is the ownership, and what is the finance of the government in such agencies that are created by the Parliament. In this case, interestingly, in the LIC Housing Finance case, the chairman and managing director of LIC was also the chairman and managing director of the Housing Finance. And the Housing Finance, it had Life Insurance Corporation had nearly 40% shareholding, right? And when it had 40% shareholding, when the title of such a housing finance has LIC, when the chairman and the managing director are the same, and Life Insurance Corporation of India probably dominates the board of directors, dominates the function, dominates the objectives of the housing finance. In those circumstances, it was not difficult for the commission to hold that LIC Housing Finance is a public authority. Right? So, Parliament creates LIC through an act, LIC creates housing finance. right? So housing finance, is it a public authority or not? I think the commission was very clear. The commission said it is a public authority, right? Interestingly, LIC comes up with a mutual fund, and it says that because it has created a mutual fund, the mutual fund is a separate agency and it is not accountable under the RTA Act, is what LIC claimed. Unfortunately, the Central Information Commission in this case said that it is not practical for LIC to take such defenses. It's not right for LIC to take such defenses as well, because finally the mutual fund is funded in terms of design. It is controlled by LIC. The affairs and the functions of the mutual fund are done by those officers who work for the Life Insurance Corporation of India, right? And hence, this mutual fund was nothing new, and it was a matter of indirect funding that LIC wanted to bring into its existence. And hence, you will notice that LIC mutual funds was codified as a public authority under the Right to Information Act.